Today we will discuss the topic of bailable and non-bailable offences under the Code of Criminal Procedure. Although the terms bailable offences and non-bailable offences have been defined, there is no definition of the term bail in the Criminal Procedure Code. So there is no definition of bail mentioned in the Criminal Procedure Code. The term bail has been defined in the law lexicon. Law lexicon, it is a kind of dictionary, legal dictionary. The term bail has been defined in the law lexicon as a security for the appearance of the accused person, security on giving which he is released pending the trial or investigation. So bail is security. Bail covers release of a person upon one's own bond, personal bond, either with sureties or without sureties. So security in the form of bond, security in the form of bond with sureties or without sureties. Sureties are other persons who undertake responsibility that accused person will remain present in the court whenever required. Or accused person will remain present before the concerned authorities whenever required. When a person is granted a bail, he is released from restraint, that is custody. He is released from custody. The word bail means release of a person from legal custody. Under the Criminal Procedure Code, offences are classified into bailable and non-bailable offences. As per the definition given in Section 2, Clause A of the Criminal Procedure Code, bailable offence means an offence which is shown as bailable in the first schedule of the code, or which is made bailable by any other law for the time being in force. So, which is shown as bailable in the first schedule. And non-bailable offence means any other offence other than bailable offence. Here, the code has not given any criteria to determine whether any particular offence is bailable or non-bailable. It all depends upon whether it has been shown as bailable or non-bailable in the first schedule of the code. So, in my previous lecture relating to cognizable offence and non-cognizable offence, there also code has not given any guideline or criteria for making such categorization or classification. So everything depends upon whether it is shown as bailable or non-bailable, or cognizable or non-cognizable in the first schedule of the code. This first schedule is the table as I explained it in my previous lecture, and in that table, in the fifth column, that table covers all the offences under the Indian Penal Code. In the fourth column, it is mentioned whether it is cognizable or non-cognizable, and in the fifth column, it is mentioned whether it is bailable or non-bailable. The first schedule of the Criminal Procedure Code. However, it can be stated that generally serious offences are considered as non-bailable. Serious offences are considered as non-bailable and others as bailable. It may also be noted that according to the first schedule, offences under the other laws than the Indian Penal Code, which are punishable with imprisonment for 3 years or more, have been considered as non-bailable offences. Imprisonment for 3 years or more as non-bailable offences, and others which are punishable with less than 3 years imprisonment are considered as bailable offences. However, there may also be exception to this rule as may be provided in any particular other law. So, other than Indian Penal Code, there may be other criminal minor acts in which offences may be defined. In the case of bailable offence, a bail can be claimed as a matter of right. So, accused can claim his release upon his bail as a matter of right. Hence, as soon as the accused person is prepared to give bail, that is security in the form of bond with sureties or without sureties. Hence, as soon as the accused person is prepared to give bail, he is bound to be released, and he is to be so released on such terms as to a bail which may appear reasonable either to the police or to the court who is granting the bail. Thus, if a person who is accused of bailable offence is arrested or detained without warrant, then he has right to be released on bail. Then what about non-bailable offence? However, it does not mean that if the offence is non-bailable, he shall never be released on bail. It does not mean that. In such case of non-bailable offence, matter of his release is left to the discretion of the authorities concerned, discretion of the court. Thus, it is a discretion of a court whether to grant a bail or not in case of non-bailable offence. We will consider some example of bailable offence and non-bailable offence. Bailable offence under the Indian Penal Code. Offence punishable under section 363, that is offence of kidnapping. Offence of kidnapping. It is punishable with imprisonment for 7 years. This offence is bailable offence. Take another example. Offence punishable under section 325 of the Indian Penal Code, that is offence of voluntarily causing grievous hurt. It is punishable with imprisonment for 7 years. This offence is bailable offence. Here we can notice that in case of both these offences, it is punishable with imprisonment for 7 years. It means that punishment is comparatively larger punishment. Then also it is a bailable offence. But these both offence of kidnapping and offence of voluntarily causing grievous hurt, these both offences are cognizable. It means that in case of these offences, police officer can arrest without warrant any suspected offender. But when such offender, suspected offender is arrested, then he has right to be released upon a bail because it is a bailable offence. Regarding non-bailable offences, examples. In fact, there is no need to give examples of non-bailable offences because, subject to few exceptions, all non-bailable offences are generally cognizable offences and which are most serious in nature. So, generally all non-bailable offences generally are cognizable offences and which are most serious in nature. So, cognizable and non-bailable offence, it is of most serious nature, and non-cognizable and bailable, or bailable and non-cognizable, such offences are less serious offence. Consider one more example. The offence which is non-bailable but also non-cognizable, non-bailable but also non-cognizable, that is offence under section 493 of the Indian Penal Code. That is offence, what is that offence? A man by deceit, that is cheating, causing any woman not lawfully married to him, causing to believe that she is lawfully married to him, and so to cohabit with him in that false belief. This is the offence under section 493 of the Indian Penal Code, which is punishable with imprisonment for 10 years. Now, this offence is non-cognizable. It means that police officer cannot arrest suspected offender without warrant or without order from the magistrate. But once such a suspected offender is arrested as per the arrest warrant which is issued by the court of magistrate, then in that case, when he is in the custody of the police, either police custody or magisterial custody, then in that case, since this offence is non-bailable, he has not right to be get released upon a bail, because in this case, whether to release such suspected offender upon a bail, whether to release him or not, it all depends upon the discretion of the court. It means even though it is a non-cognizable offence, there also, since because it is a non-bailable offence, it is of serious nature. So we have finished the discussion on this topic of bailable and non-bailable offences. We will see some another topic in our next part of the video lecture. Thank you.